Looking back on 2020, 17th of March. On this day, the Robert Koch Institute categorized the risk to the health of the population in Germany from the coronavirus as high, as we know by now, without verifiable data. Then came the lockdown in Hamburg. That means the most severe restrictions on fundamental rights that had never existed in Germany before. On 23rd of March, the then Federal Minister of Finance, Olaf Scholz, stated in a press conference that the emergency coronavirus aid was a grant that didn't have to be repaid. His statement was published on the website of the Federal Ministry of Economics, and it was never corrected or denied. Due to the government measures, I saw as a self-employed courier driver a considerable loss of turnover coming my way, and therefore applied for Corona emergency aid as state support in this exceptional situation. The economic consequences of this state of emergency were incalculable for me, which means the actual expected loss of turnover could only be estimated. Later it became clear that the emergency aid must be repaid under certain conditions. Self-employed applicants had to prove that they had actually needed the funds, otherwise repayments were demanded. This led to criticism and legal disputes, as many recipients referred to Scholz's original statement. After being forced to give up my business, I didn't earn enough to fight it out with a lawyer. After serving the other creditors with small installments, I had to file for insolvency in April 2025 after 3 deferrals of Corona aid. On the occasion of my insolvency, as a direct consequence of the reclaim, I now ask the Investment and Development Bank to withdraw its claim. My application decision was based on my trust in the government, acting in accordance with the rule of law. This administrative act can, protected by the basic law, be cancelled retroactively as unlawful. I have pointed this out to the Investment and Development Bank by email and asked for it to be reviewed by the date of the meeting with the insolvency administrator on 13th of May 2025. Here's my email text. Urgent review of the recovery of Corona emergency aid, Investment and Development Bank application number so-and-so, Ruth Gade booking number so-and-so, insolvency proceedings Ruth Gade, reference 68A IK 203/25. Dear Sir or Madam, I am contacting you today with an urgent request for an examination. I was granted emergency coronavirus aid by IFB Hamburg in spring 2020. At the time, I applied for the funds on the basis of the public assurance given by the then Federal Minister of Finance Olaf Scholz, who emphasized in his public statements, including on the website of the Federal Ministry of Economics, that it was not a loan and that no repayment was required. This promise was crucial for me as a solo self-employed person. At the time of the application, I had assumed that there would be a significant drop in turnover, which did not materialize in this form. However, this was not foreseeable at the time of the application. I acted to the best of my knowledge and in an existential emergency. I was all the more surprised by the subsequent re-registration procedure and the reclaim that has now been made. I placed my full trust in the statements of the federal government. In my view, a reclaim not only seems unfair, but also violates the principle of protection of legitimate expectations that applies in administrative proceedings. In its judgment of the 28th of April 2023, case number 16K 5209/21, the Hamburg Administrative Court also made it clear that the original statements could be relied upon. In the meantime, insolvency proceedings have been opened against my assets on 23rd of April 2025, Hamburg Local Court Reference 68A IK 203/25. The official notice of insolvency dated the 29th of April 2025 is attached to this email. I have an appointment with the insolvency administrator on Tuesday, 13th of May 2025, which is why I would ask you to consider my request urgently until then. I therefore request: first, cancellation of the recovery notice; second, recognition of my legitimate expectations; third, and alternatively, full remission of the repayment for social and humanitarian reasons, based on Section 59, Paragraph 1, Administrative Constitution Act in conjunction with Article 20, Basic Law. According to Section 59, Paragraph 1, Administrative Constitution Act, an administrative act can be cancelled in whole or in part with effect for the past if it was unlawful. Article 20 of the Basic Law protects confidence in the administration acting in accordance with the rule of law, in particular if, as in this case, a public commitment was the basis for economic action. I'm of course at your disposal for further questions, and thank you in advance for your favorable consideration. Yours sincerely, Ruth Gaddu.